Right, good afternoon everyone. Welcome to the Cheltenham Borough Council Licensing Subcommittee for Alcohol and Gambling, which is being held today, Thursday the 27th of March 2025. My name is Councillor Dr David Willingham and I have been elected as Chair of the Committee. The meeting is being streamed live to Cheltenham Borough Council's YouTube channel and a recording of the meeting will be held for 4 years. If there are any breaks in the transmission to the YouTube stream, then the meeting will be adjourned for a short period until any technical issues are resolved. To the members of the public present, if you are here to make representations to the meeting, you are consenting to the use of the sound and video recordings for broadcast and training purposes. Please also be aware that CCTV and audio recording is now in operation in the public gallery. The recordings will be held by the Council for 5 months. A fire alarm test is not expected, so if the fire alarm does sound, you should immediately make your way out via the nearest exit, which is either the door that you came in through or another one to my right there. If there is an emergency and we do have to evacuate, then you will be accompanied by a member of staff. If you've got mobile phones or anything else that makes a noise or pings, I would be grateful if you could put it on silent for the duration of the meeting. So that covers agenda item 1 of me being elected chair. Agenda item 2 is apologies. There are none. There's 3 of us here. Agenda item 3 is declarations of interest. Councillor Harvey.
Thank you, Chair. Can I refer the committee and officers to my declarations of interest in the members folder? I am actually a licence holder. I did my MVQ level 2 and I'm licensed by Cheltenham Borough Council to sell alcohol on and off premises. Obviously I'm dealing with this in my capacity as a committee member, but I have been trained and I am a licensee.
And I believe it probably needs to go on record that I was chairing the previous meeting. And I think Councillor Barrell was present, if that's correct. Just let me check. Got the minutes up somewhere. Bear with me a second. Yeah, so I was chair, and who was the other member?
Simon, I think.
Councillor Wheeler. Okay, so that isn't a prejudicial interest, it's just for the record so that everybody knows that some of us have seen the previous committee, but not all of us. So now we move on to the substantive item, which is agenda item number 4, which is a Licensing Act 2003 determination of application for review of a premises licence in relation to bargain booze. So because this is a regulatory item, members must be present and have heard the proceedings in their entirety to vote on this item. We will ensure that the review applicant and their representative responsible authorities, interested parties and the premises licence holder and their representatives are present in the meeting. I will ask the licensing officer to introduce the report. Committee members and then other parties will get an opportunity to ask the licensing officer questions. We will then give the review applicant the opportunity to present their case for the review, and we ask that this be limited to 10 minutes, but if you need more, then let us know. There'll then be an opportunity for members to ask questions. There isn't cross-examination, but if there are questions from the premises holder, they can be put through the chair. We'll then provide the premises licence holder and their representative the opportunity to present their case, and again there will be the opportunity for questions from committee members and no cross-examination because this isn't a court, but if there are any questions they can be put through the chair. I suspect that we may provide our thoughts as committee members so that there's transparency. We'll then invite final comments from the licensing officer and the review applicant, and the premises licence holder will be given the final right of reply. We'll then adjourn and hopefully come back and inform all parties of the decision. So hopefully that's clear for everybody. And with that, I will ask the Licensing and Public Protection Manager to introduce the report, please.
Thank you, Chair. This licensing subcommittee has been convened due to a review application being submitted by Gloucestershire Constabulary in their capacity as a responsible authority. The application seeks to review the premises licence for Bargain Bees Select Convenience 216 to 218 Hewlett Road, Cheltenham. The review application was made under the Prevention of Crime and Disorder and the Protection of Children from Harm licensing objectives. The grounds for the review can be summarised as follows. The premises, Bargain Bees on Hewlett Road, Cheltenham, was subjected to a review application initiated by Gloucestershire Constabulary on the grounds of persistently selling alcohol to children, and that initial review took place on the 4th of September 2024. The outcome of that hearing was as follows: the immediate removal of the current DPS, Designated Premises Supervisor, the suspension of the premises licence for a minimum period of 4 weeks to allow for the appointment of a new DPS. This suspension could be extended to a maximum of 3 months to ensure sufficient time for the nomination of a new DPS. The imposition of new conditions on the premises licence as detailed in Appendix 1 of the decision notice. Since the 4th of November 2024, the premises has been selling alcohol without a DPS in place up to the 23rd of January 2025. This is a breach of the mandatory conditions of the premises licence and the Licensing Act 2003 and fails to comply with point 2 of the hearing outcome as determined by the Licensing Subcommittee in September of 2024. Additional grounds supporting this second review application are provided below to assist the committee in its considerations. The second review application pertains to the sale of alcohol being conducted otherwise than other and in accordance with an authorisation. The premises licence holder for Bargain Bees is Mrs Dalwinder Kaur, who is present today. Further evidence to support the review application is that on the 23rd of January 2025, PC Sansom of Gloucestershire Constabulary attended Bargain Bees and observed that the store was open with alcohol visibly on display for sale. There was no designated premises supervisor, DPS, in place, and Part B of the premises licence was neither displayed nor available for production. Whilst PC Sansom was in situ, customers were coming in, attempted to buy alcohol, and he provided advice that alcohol cannot be sold at this time to the licensee and her daughter, and they did adhere to that advice. A till receipt was obtained, which is in Appendix 3 of your papers, confirming that alcohol sales were taking place, and 6 photographs were also taken on site showing alcohol on display for sale, which is also in your report papers. On the 27th of January 2025, PC Sansom sent an email to the licensee, Mrs Dalwinder Kaur, requesting evidence that the premises had complied with the premises licence conditions set during the last hearing, specifically regarding staff completing an online training course. No reply was received. Licensable activities, specifically the sale of alcohol, have been conducted between the 4th of November 2024 to the 23rd of January 2025 without a DPS in place. The licensee has once again disregarded the importance of adhering to the premises licence and legal compliance. Since the review hearing, no contact has been made with the police licensing officer or, to his knowledge, the local authority licensing team by any representative of Bargain Bees seeking advice or guidance. At the September hearing, a condition was added to the premises licence stating any staff member involved in the sale of alcohol or age-restricted products must complete an online training course for age-related product sales. The course must produce a certificate of completion upon passing the online test. It must be endorsed by the British Institute of Innkeeping awarding body and refreshed every 12 months. To date, no evidence has been provided to confirm that this condition has been implemented, despite an email being sent to the licensee on the 27th of January 2025 requesting proof of compliance. At the previous hearing, the police made it clear that should the premises licence holder fail to learn from that review, the police would seek a revocation of the premises licence in the future. This submission and appended document provide the licensing subcommittee with background arguments and information pertinent to that contention. These provide the subcommittee with a sound and defensible rationale as to why it should revoke the premises licence. Following PC Sampson's visit on the 23rd of January, an application to appoint a new designated premises premises supervisor was made immediately. The premises are licensed for the hours and conditions attached to the premises licence, which is included at Appendix 2 of your report. The grounds for the review can be found in Appendix 1 of the report. The application has also been subject to a 28-day consultation with all of the responsible authorities specified under the Act, published on the Council's website, at the Council offices, and also public notices were displayed at the premises for 28 days. There were no further representations received from any other responsible authority or any other person under the Licensing Act during that 28-day consultation period. In determining the application, the Licensing Subcommittee must have regard to the statutory guidance issued by the Secretary of State, the Council's adopted policy statement, the representations made and the evidence it hears today. Extracts of these documents are included in your report papers. The options for the subcommittee today, having regard to all of this information and taking steps as it considers appropriate for the promotion of the licence and objectives, can include making no changes to the current premises licence, modifying the conditions of the premises licence, excluding a licensable activity from the scope of the premises licence, removing the current designated premises supervisor, suspending the licence for a period not exceeding 3 months, or revoking the licence. The committee are reminded that the police are seeking revocation of the premises licence. Thank you.
Thank you very much. Are there any questions for our licensing officer from members of the committee? Councillor Barrell.
Right. Now, am I right in assuming there is now a DPS in place, officially authorised? Right. And the other thing, have you had any information about online training courses having been taken by the members of staff, which was another condition that was put on last time?
Thank you, Chair. Firstly, yes, there is a DPS on the current premises licence and they're currently licensed to sell alcohol. DPS is present today. We haven't had any evidence of online training courses being completed.
Any further questions? Councillor Harvey.
Thank you, Chair. One DPS was removed in the past. Can I just ascertain whether the current DPS is not that same person that was removed in the past? It's a different one.
The previous DPS is the premises licence holder that is today, Mrs Dalwinder Kerr. The current DPS is a different DPS to the one that was on the licence when you had the last review application.
Thanks. I've got a couple of questions for you. So in terms of any documents supplied prior to the hearing, can I check whether we've had there haven't been any further documents submitted to the council before the hearing?
No, there hasn't, Chair.
And in the time between the suspension expiring, or the review, and now, do you know what contact there's been with either the premises licence holder or the DPS between and the council?
So after the last review hearing, a visit was made to the premises on the 17th of October 2024, and no alcohol sales were taking place on that date. There were curtains across the chiller cabinets, and a colleague from Neighbourhood Services confirmed there was no alcohol being sold. The next visit took place the day after the review application was submitted by Gloucestershire Police, and that's when I personally went out to display the site notices that we have to display under the legislation, advertising a 28-day consultation period.
And finally, can you just go through what the responsibilities are for the various parties, just so we've got it on record in terms of the licensees' responsibilities and the responsibilities of the DPS, please?
Thank you, Chair. The premises licence holder is the person that's ultimately responsible for the premises licence, and that's to ensure adherence to the conditions that are attached to that licence, ensuring that the times and activities are complied with. They are also responsible to ensure that the Part B of the premises licence is on display, and also Part A is kept in a safe place and that everyone's aware of the conditions on that licence. The DPS, the designated premises supervisor, is the person that's responsible for the sale of alcohol, and they would authorise all alcohol sales at the premises. But together they're responsible for the sale of alcohol.
Thank you. Right. I'm not seeing any further questions. So are there any further questions from the review applicant? Are there any questions from yourself as the representative of the licensee?
Thank you very much, Chair. I was present at the last hearing when this happened. According to what the report on 23rd January, without a designated at the DPS, the licensee has once again disregarded. When the email was sent in, my client says that there was a reply made to you on the 5th of February with the certificates and all that. Can you correct that, please?
Can you confirm, it's probably worth knowing who it was sent to. Was it sent to the police or was it sent to the licensing authority?
It was sent to the police.
So it was sent to the police?
Yeah, the
Okay.
certificates. And
I think we'll have to ask the review applicant that one when we get to that part of the hearing.
Send 3, 4 and reply them at the same time.
that's all.
That's the only question. Okay. So now we will move on to the opportunity for the review applicant to present their case. So if I can pass over to PC Batty, please.
Thank you, Chair. Good afternoon, everybody. Hopefully you've had an opportunity to view the papers of the case that we bring before you today. Please accept our apologies for PC Sampson not being able to be present here today. However, he's done a marvellous job in presenting the evidence that we've gathered so far. Before I delve into circumstances why we appeared before you today, I wonder if you'd oblige me just to summarise some of the previous bits that were on the hearing. There is a clear link to both review applications. That's why I mention it. And obviously that's the undermining of the licensing objectives. It's already been mentioned in regards to the review that actually took place, but the minutes that were attached to also this review hearing would have been sent out to the licence holder and the respective representative. It mentions in regards to that comments were made, and it says the solicitor on behalf of the licensee then addressed the committee and made the following points. If the licence were revoked, then the current licensee would be homeless. The solicitors provided new conditions, for example, CCTV, etc., paraphrasing on here now, but then the last bit on, there will be staff training and a refusal book. A month's suspension is enough to make the changes and to get a new DPS in place. It then went to members' questions, who asked the representative, and it says the solicitor appointed undertook to ensure that the changes happen now that they've been appointed. Would the solicitors help the application for a new DPS should go through smoothly? And the licensee will remember it's illegal to sell to under 18s. It is apparent to us that some of these open promises provided to the respective panel appear to just be a bit of lip service to avoid revocation. I understand that at the previous hearing, the officer, as already been mentioned, made explicitly clear that should the premises licence holder fail to take corrective action following the review, then police would seek revocation of the premises licence. Now, Gloucestershire Constabulary clearly do not want to be making anybody homeless, but on the same hand, we cannot be accountable for the failings of others who are in a position of responsibility, especially in the light of previous review hearings and that of today's. This is about undermining of the licensing objectives. It would be reasonable to expect that should the premises licence holder, fearing being made homeless, if the licence were revoked, that they would have concentrated the mind somewhat and ensured compliance. Instead, this brings you on to why we appear before you today. As already mentioned, on the 23rd of January 2025, as documented in Appendix 1, which is a statement of PC Sampson, The officer attended the premises and upon entering, he observed that alcohol was visibly on display. These are clearly depicted in his appendixes 3 to 8, which are the photos of the alcohol on display. The officer was certain that no application to vary the DPS had been submitted and therefore no alcohol sales should have been taking place. As outlined in the officer's statement, the officer spoke to the premises licence holder, Mrs. Dalwinder Kerr, who was present inside the store. The officer asked whether they'd been selling alcohol, to which he confirmed they had been doing so, and since around the 4th of November 2024. The officer also inquired about the change of the DPS, noting that he had been under the impression that her daughter was due to take on this responsibility. Mrs. Kerr responded that the matter had been handled by their solicitor. At this point, the officer requested to see the premises licence holder and the summary, which is Part B, to verify the details of the new DPS. However, these documents could not be produced. Frankly, the reason why they could not be produced is because they did not exist. While on site, the officer contacted the licensing team at Cheltenham Borough Council, who confirmed that no application to vary the DPS had been submitted and agreed that the alcohol sales should not have been taking place. Mrs. Dalwinder Kerr then called her daughter, who arrived a few minutes later. The officer reiterated that alcohol sales were not permitted in the absence of a valid change of DPS application. And this was in breach of the premises licence. Her daughter believed that the solicitor had taken care of the matter. That's what the officer was told. The officer reminded Mrs. Dalwinder Kerr that as premises licence holder, it's her responsibility to ensure all licensing documentation is accurate and the business complies with the premises licence conditions. Now you will see in Appendix 2, that is the till receipt that the officer obtained, and it clearly shows that the extra evidence that alcohol sales were occurring, and that was even the day before the officer attended. The officer instructed them to cease all alcohol sales immediately and explained that he would liaise with the local authority's licensing team, requesting that a member of the team contact them to assist with the varied DPS application and clarify when alcohol sales could resume lawfully. Following the officer's discussion with the licensing team, he returned to the police station and reviewed one of the additional conditions imposed at the previous review hearing, which states, any member of staff involved in the sale of alcohol or age-restricted products, must complete an online training course for age-related product sales. The course must produce a certificate of completion upon passing the online test. It must be endorsed by the BIIAB, which is the British Institute of Innkeeping Awarding Body, and refreshed every 12 months. 27th of January 2025, the officer subsequently emailed Mrs. Dalwinder Kerr requesting evidence of this training that had been completed, and that is in your Appendix 10. You will see the date and time, etc., that was sent from the officer. To date, no such evidence has been provided to confirm compliance with this condition. Since the previous review hearing on the 4th of September, there has been no contact from Bargain Booze or any of its representatives with either the officer or, to his knowledge, the local authority's licensing team seeking advice or guidance. As already mentioned, the DPS is usually the person that's given responsibility of the day-to-day runnings and being in charge of the premises. Even the DPS, who has only recently obtained her personal licence, has failed to produce compliance to the officer also. As recently qualified, the DPS should have a fresh knowledge of the legal requirements, such as things as well as best practice and due diligence. However, these do not appear to be phrases that either the DPS or the premises licence holder are familiar with. The 27th of March 2025, we appear before you today and to reiterate that to date, and exactly 2 months ago, no evidence of compliance as requested by the officer has been produced by the licence holder or representative. As police alcohol licensing officers, we seek to adopt a staged approach when dealing with the licensed premises to try and deal with matters cooperatively at a local level, to prevent having come before you before a subcommittee today. Sometimes this is not the case, as it's not possible. We will engage and work with operators to ensure that they're aware of the principles of best practice, but it remains a responsibility of operators to ensure their respective premises run safely, responsibly, and legally. The premises licence is a legal document. The approach provides ample opportunity for respective operators to review working practices and take any appropriate action deemed necessary to avoid potential enforcement or review application. Sadly, even with the best efforts and intentions, some operators make a conscious decision to ignore ourselves, and even in this case, yourselves. The respective officer took a stated approach prior to the previous review hearing, and upon discovering that the licensing objectives were being undermined again, clearly had no choice other than to bring the matter before yourselves today. There are several relevant conditions on the licence, and as you've heard to date from the officer, that no proof of compliance has been received from the licence holder. There are several offences that would be relevant in this matter, and outlined in the review application. The licensing authorities do not have the power to judge criminality or otherwise of any issue. This is a matter for the courts. The licensing authority's role is determining whether such a view is not therefore to establish guilt or innocence of any individual, but to ensure the promotion of the licensing crime prevention objective. Apologies. We are not asking the panel to judge guilt. That is not your role. We are, however, asking the panel to ensure the promotion of the crime prevention objective by respectfully determining revocation. I think, however, it would be prudent to address the following, as it shows a blatant disregard for the Licensing Act and undermining of the licensing objectives. And these are Section 135 of the Licensing Act 2003. The licence holder's duty to produce the licence wasn't done. Section 136 of the Licensing Act 2003, unauthorised licensable activities clearly been taking place. Section 137 of the Licensing Act 2003, exposing alcohol for an unauthorised sale, as depicted in Appendices 3 to 8. Section 138 of the Licensing Act 2003, keeping alcohol on premises for unauthorised sale, as depicted again. Section 139 of the Licensing Act 2003 provides a defence of due diligence. Now, whilst the premises licence holder may claim such a defence in that she were reliant on information given to her, for example, we would argue that clearly not all reasonable precautions were taken and that the licence holder did not exercise all due diligence. Annex 1 of the premises licence clearly states, Condition 1, no retail sale of alcohol may be made under the premises licence, A, at a time when there is no designated premises supervisor in respect of the premises licence. Thank you, Chair and panel, for hearing this review today. I now leave myself available for any questions that you may have. Thank you.
Thank you very much. Do we have any questions from the committee? So I've just got one which I think I know the answer to, but the officer, PC Sansom, how would he have known that the DPS application hadn't come in? And I'm assuming that that is because he, as a licensing officer for Gloucestershire Constabulary, he would be one of the responsible authorities consulted on such matters. Is that correct?
Thank you, Chair. Yeah, absolutely correct. Any application would get submitted to the local authority, which in case yourselves, obviously, and then as a responsible authority, we would get disseminated a copy of that application. It would either go directly to the officer himself or it would go to the licensing inbox. Either way, I mean, it depends how it's worked out with the Cheltenham Borough Council, but either way, we would receive it as a responsible authority, and clearly that had not been received. That's how he would have known.
And I think taking the question that's come from, that was posed to the licensing officer, suggesting that some emails had been sent, I think was the 5th of did you say the 5th of February? Do we know whether those emails have been found? I'm guessing it's a bit difficult to look in someone else's inbox.
Thank you, Chair. No, unfortunately, I cannot answer that question. I wouldn't have access to any of his personal emails. Clearly, if you do have an email that could be presented to yourselves, then that's a matter for yourselves to take into consideration.
Okay. I'll just look to my colleagues. Are there any further questions? Councillor Harvey.
Thank you, Chair. The police are a statutory consultee for licences. Are you aware of how many times the particular licence holder has gone to the police as part of a licence application? In other words, They have one licence that I'm aware of. Are there any others that the police are aware of at other locations within Cheltenham or elsewhere?
Thank you. So are you asking specifically in regards to the licence holder or the DPS in this occasion? Yes, according to our records, I looked earlier on and you've got the premises licence holder is shown at another premises in Cheltenham. But as far as that, I can't give you much information about the operation, I'm afraid.
No, that's fine. Thank you.
Chair, apologies. If I may just, I don't know whether it's appropriate to do it now or questions for the other party afterwards, but in specifically the email that's been sent, maybe it might be helpful to determine the context of that email and if it relates to any training, specifically the dates in terms of when the visit was done, post the review hearing, etc. But respectfully, I'll leave that for your determination.
Yeah, thank you. I was going to ask you another question, but it slipped my mind now. So bear with me a second. I may come back to you. So if there are any questions for the officer through the chair, if you would like to present them, it may be that we get you to forward that email to our democratic services, and then we will take a short adjournment to just allow everybody to have a look and see what that information is. But if I ask you, Mr. Panchal, do you have any questions for the officer through the chair? Right. I've remembered the other question I was going to ask you now. So sorry. One of the comments we made at the time, which wasn't a condition, but was about the youth antisocial behaviour if refusals were made. Do you know whether there has been much contact with the neighbourhood policing team or 101 or the force control room in respect of any issues of youth antisocial behaviour following either refusal or anything else that would be relevant and material?
Thank you, Chair. No, looking at it, there were no apparent records linked to the premises itself in relation to that since the review. But whilst you bring that up, obviously there is a relevant condition is attached to the licence, which relates to refusals. And it specifically says the refusals book shall be kept in licensed premises and made available for inspection by the licensing officer, training standards, or the police upon request. Perhaps that question would be best asked to the other party, respectfully, Chair.
I think in the interests of being able to share the emails and what have you, if we just adjourn for 5 minutes just to allow that to be shared, printed and what have you, so that everybody can have an opportunity to look at it. So I'll pause the meeting. Okay, so for the members of the public who may be watching, we have had an adjournment to decide whether some emails that have been submitted late by the premises licence holder will be admitted, and we've just gone through some questions to look at that. So we are going to accept the emails in the interests of a fair hearing. And there are now some questions from the licensing officer. Michelle.
Thank you, Chair. It's not so much a question, it's just an observation from my visit to the premises. So the document that's just been accepted is the personal licence certificate for Navjinder Kaur, who's the DPS. When I have visited the premises, Mrs. Dalwinder Kaur has been selling alcohol, and also there was another gentleman selling alcohol when I visited. So I believe that may be her husband, just to let you know that obviously this is just one training certificate that we have in front of us. Thank you.
Thank you. Right, if we now move, so where were we? We were questions, whether there were any questions from the premises licence holder through the chair to, in which case, I think you shook your head, so it's now your opportunity to present your case, and I think there may be some questions for you afterwards. So if you can press the button when the red light's on.
Thank you very much, Chair. Chair, I'm going to briefly first answer or present myself to the presentation done by the police officer and clarify a few matters, and then put the further question. Number one, Navjinder has been trained. She was trained under the BII. You got the certificates now with you. Without that training, she would have not been issued with a personal license. So that personal license was issued on 31st of October 2024. She was issued with a personal license with that certificate. Dalwinder Kaur, who is the license holder, also holds a personal license and has had a training from BIIAB for having that personal license. She used to be the DPS before, so she has already undergone the training. That's one of our replies to you. Yes, we agree. We're not going to dispute a lot about what happened on 4th of November. The license, when we came to the last hearing, which was then suspended, and change of DPS was to be carried out. I don't carry out the applications for DPS. I carry out the hearings and that. And PLC UK were given, where Navjinder had her trainings, were given the documents to make sure that after the suspension of the license, which was the 4th of November, they would carry on to licensable activities subject to change of DPS. Navjinder did ring the office at PLC to carry out the necessary change of DPS, hence she can carry out the licensable activities at the premises. She was assured by the PLC UK Limited that yes, the application is going in and you can carry on selling the alcohol. And that is why on 4th of November, Navjinder went ahead and opened the shop, and she was told that it'll take the license to come in. As soon as it comes in, we'll send it to you. Unfortunately, when I spoke to PLC, it was found out that the application had not proceeded out of the office for some sort of reasons, which was laid out at the premises there, and they've all forgot about it. That's what the reasons given to me by PLC's staff there. I'm also part of the PLC, so I'm not saying that I'm not part of the PLC, but I handle the hearing department of it. So we do, an apology has been made by the PLC to say, well, we left it. And as soon as the visit was made by the licensor, the NIC at the premises, it was then realized by Navjinder that, well, the application hasn't been made. So she immediately rang the PLC and said, hey guys, I've been told the application hasn't been gone in. Can you do the necessary? And immediately the shop was closed. Whilst the application was carried out, the application was received at the premises, at the council, and thereafter the shop was opened. And that is one of the reasons that the shop was open without a license. So it wasn't Naujinder Kaur. Naujinder Kaur does understand that she cannot trade. She does understand the full licensing objectives. She does understand what she has to do apart from the CCTVs and necessary things, because I have been to the shop this morning when I came in for this. There is a refusal book at the shop which is carried out. There are refusals logged into the refusal books. So that compliance is carried out. There were incidents at the nearby the shop. They were also recorded. So the incident book is taken care of. There is a training manual at the premises. All the posters necessary required challenge 25, all of them are in place at the shop. On 12th of November 2024, there was a trading standards visit also on 12th of November at the premises for a test purchase, which again, the test purchase was passed. We have the certificate for the test purchase. The test purchase was carried out by the officer, Sarah Watson. So we have that, if you want to have a look at that. So test purchase was passed, a certificate was issued, and there was no underage sales carried out on that premises. So, Chairman, we have complied. We understand the problem that Naujinder went through from 4th of November to January, which the officer is putting his case forward to. Again, she was very annoyed with what had happened and what the company did, that they did not send in the change of DPS application, which was overlooked in the office and not sent in. They were very apologetic for that. So, Chairman, that is why the matter had happened at the premises. Trainings are carried out on regular basis. There are 2 people serving at the shop. The previous underage sales, when we came down to you, was Mr. Dalvin Kaur's husband. He is now not allowed to go behind the counter at all. At the present moment, he is in India. And when the Naujinder and Dalvin and all the family went up to India, they decided not to trade. They decided to close the shop because they could not find anybody capable enough of running, or they did not want to take any risk. So the shop was closed, and they've just come back from India for the event that they had been to, which was pre-booked on 24th of this month. So, Chairman, that is our report of what happened. They are very apologetic. Naujinder is very apologetic for what happened during the period of 4th November. Yes, we would say that under the guidance and the section that the police is mentioning should have not been traded. So we raise our hands up and say, yes, there was a fault. Yes, she could blame the company as much as she wants, but she carried out on the pretext that the company had said to her that the application had already gone through. So, Chairman, that's what our presentation today is.
Right, thank you. Now there's an opportunity for councillors, first of all, to ask you any questions. Are there any questions? Councillor Barrell. Turn them.
Thank you very much. I remember at the last hearing, I was very impressed by the way you were going to ensure that everything went well. And I'm disappointed that things have not worked out this time. Could you just explain to me, this company, was a company meant to send the certificate to the Cheltenham Borough? You said something about the BLC didn't carry out their work. I don't understand that.
BLC company is the one.
Could you use the microphone, please?
Sorry, Chair. The company PLC was supposed to put in the application for change of DPS, which was what Naujinder had given that job. Which I'm part of that company also, but I do the hearings and I don't do that administration work. So that staff was supposed to carry out that and send the change of DPS to the application of change of DPS to the council. So they prepared the document but did not send it. They were waiting for the suspension because the 31st of October, her personal license had arrived. So after that, they were supposed to send that application through to the council. They overlooked it for some reasons and it laid in. And that is one of the reasons that wasn't sent in. Oh, sorry.
Yep.
Sorry, yes. I've lost the thread. The application should have been registered, you're saying, by this company. That would be the normal procedure, presumably, but it wasn't. Okay. I seem to remember something about that the premises license should have been on display. Wouldn't it have been obvious if there was no premises license on display that there was a problem somewhere, you know, along the way, as it were?
So from my experience, ma'am, and the license officer would tell you that once an application of transfer of DPS is carried out, it normally takes a week or two further down the line for the council to prepare the documents, so they have to wait for the police to approve. That is, I think it's a 14-day period where the police would approve that document of DPS and send it back to the client. But in the guidance, section 182 says it is an immediate effect, if I'm not mistaken, and it becomes an immediate effect.
Do you want to clarify, please?
Thank you, Chair. Yes, with an application to appoint a new DPS, you can tick a box where it is with immediate effect. There wouldn't be any premises licence issued at that point in time. There's a 14-day consultation period with Gloucestershire Constabulary. However, when PC Sampson went for his visit, Part B wasn't on display because we hadn't received a DPS application.
Yep, go for it.
Yes. Now, I realise that this certificate is just for one person. What about all the other people who should have done this training course? Have we got records? Apparently, you were going to send some certificates or something which don't seem to have arrived.
Ma'am, there is only one other person who is supposed to work in the shop with Naujinder, and that's the mother who is the license holder. She already holds a BIIAB certificate because that is how she's obtained her personal license.
So you're saying that there is nobody selling alcohol who hasn't got some sort of certification saying it's okay for them to do that? Sorry.
Presently, they do not employ anybody at the present moment. It's the family running the business, and that's two people who are running the business.
Right. Councillor Harvey.
Chair, thank you. When I undertook my MVQ level 2 in licensing, it was a day-long course with an exam. I worked for a national organisation who had a legal department, but it was still expected of me to apply to the local authority for the Schedule A, Schedule B, and DPS, all the rest of it. So can I just, and I'm asking this question, I know Councillor Barrell's already asked the question, but I didn't quite hear the answer properly. So if I could ask it again, please, particularly as this has been recorded and there are people outside this chamber who, like me, might be going, PLC. Now, PLC is a public limited company. Is PLC a business that is basically a third party who you paid to make your application on your behalf? Is that who PLC is?
That's correct, yeah.
Okay, thank you.
Okay, so I've got a couple of questions for you. So what you've told us here, you've said that PLC, this company that you work for, that is another part of which processes the applications, made an error. Now, it should have been when the notice of this review hearing was communicated to you, it should have been clear in there that any material for inclusion in the hearing, so written material, should be provided 2 clear working days before the committee. And I'm just wondering why. It's all very well for you to say this, but there's no documentary evidence from PLC presented, and I'm just wondering why nothing has been presented to the committee within that time. We've adjourned once to print off an email, so it does concern me that we've got what you've said, but we have no written evidence of this, and I just wondered if you could explain why nothing's been presented.
All I can apologize is if the evidence hasn't come from PLC, but if you need so, they will be able to write it to you.
And a second question. So in the email that we've been sent, so there was a response on the 5th of February to an email. I'm just going to check when the email. So we had an email sent by Police Licensing. Let me find when it was sent. But it was at the end of January, and it got a reply on the 5th of February, which said that your colleague was, so 5th of February email that we've had, said that yourself was on holiday until the 11th of March, and the certificate would be sent back after that point. In terms of having these documents and producing them, it seems to me that the licensee should be able to produce those, because if someone's away and the police are having to wait over a month for documents that should be available on request, that's likely to lead to quite a lot of complications. So could you explain why the licensee doesn't have these documents to produce on request to the police, and they need to go through the third party? Because we've got the email saying we can't produce them for over a month.
Sorry, I'm going to ask the client to reply to that. Certificate to page up, ne?
Yeah. Yeah, but
Come forward in.
hi. I think I received email from police officer on 3rd of February or something like that, and 5th of February I sent mine because I have that day my certificate on me, and whatever he asked, and I sent to him because I wasn't sure where his mom's certificate, and I spoken to Mr. Panchal. If we're going to apply the next staff, more staff for the shop and stuff. Then I ring Mr. Panchal. He said, okay, if we provide him more staff and staff for the shop, then we can arrange the they can have a training there, and they can make, they can send the certificates as well, because we was try to because we was going to India, and we was trying to get the staff and stuff, but then we find no one, and it's just only me and my mother-in-law left with the certificates. And then no, that's why we have to cancel the shop, close the shop as well that period, because we couldn't find no one to that.
So the licensing officer's got another potentially technical question for you.
Thank you, Chair. So the licence condition that was imposed at the last review was that there should be refresher training every 12 months. Mrs. Dalwinder Kaur applied to be the licence holder and the DPS in 2021. So we haven't got any other evidence that any training has been done since she obtained her personal licence through Stratford-upon-Avon District Council. Could we just clarify that, please?
Did you hear that question? Or do you need it? Do you want to reiterate it again? Sorry.
Thank you, Chair. So Mrs. Dalwinder Kaur has her personal licence qualification. Can you just confirm when that was done, when that was carried out and awarded?
2000,
2000.
maybe 2002 or 2000. But she done manual training, which I showed you the book earlier.
Yeah. She's done manual training after that also.
Thank you, Chair. Do you have evidence that any refresher training has been done in the last 12 months, which is the condition that's on the licence from the last review hearing?
Can you use the
Sorry, the license was granted at that hearing. So after that, they have a training manual at the shop, under which the training manual in 3 months, 4 months' time, Naujinder is going to train, go through the training again.
Right. I'll now look to our review applicant, whether there are any questions that you have through the chair, please.
Thank you, Chair. If you permit a few, if I may. First one would be, why no contact made with Cheltenham Borough Council?
So if you're happy to answer that one, why there's been no contact with the Borough Council, the licensing team?
Well, in terms of the applications, since the review, the evidence to provide, we're in there was a 28-day consultation. It's not just the police that you could contact the Belmont Council as well.
I did email to the council that at the present moment, when they left for India, when Naujinder and they left for India, they said as soon as they come back. So I did reply back to the email to say although we're appointed, but we're not appointed till they come back and tell us that yes, you go ahead with the application, which was on 24th. They come back.
Second.
Thanks, Chair. The question would be in terms of, does the licence holder have any tangible evidence, not just words, that can be provided today relating to the attempts to vary the DPS, or the attempts other than just to try to defer the review hearing of providing compliance and advice?
Chairman, as I have just presented or just spoken to you through, that there is an incident book which is logged in and carried out from 1610 right through till 612 of what the incidents occurred at the shop. There is also a refusal book which is carried out in January, February for the refusals carried out at the shop.
Okay. Next question.
Thanks, Chair. That didn't actually answer the question, but that's absolutely fine. We have an answer. Can I ask, in terms of, you said there was a trading standards visit on the 12th of November, and you said that they were happy with this. I'm not aware that trading standards do for alcohol. It's only vapes or similar material. So can you enlighten us on that, please?
Yeah, the test carried out was on vapes, we agree with that. The test was carried out on vapes, but again, when they come in, it was an underage who would come on the counter, try to buy vapes, which was refused. It clearly says the proof of age was asked to the client.
And next one.
Apologies, Chair. Just a final one. It probably more an observation as opposed to a question as such, but the respected gentleman reiterates that he does the hearings on behalf of his client. So he would understand the power of negotiation, if you like, to try and negate going to a review and presenting the evidence in a timely manner so we can all look at it. Perhaps had the evidence in its entirety satisfied us, that would be different. But unfortunately, it doesn't at this stage.
I think at this point, rather than that, since that was just a statement, I'm minded to simply move to the final rights of reply at this point, which will allow us to then move to deliberate and adjourn to deliberate. So I'll run through the list that I've got. So if I can give the licensing officer the opportunity to make any final comments.
Thank you, Chair. I think the only comment I would like to make is when I visited the premises to display the site notice, I did offer the advice that you could make a written representation during the consultation period to include in the report papers, but we didn't receive anything. Thank you.
Thank you. So now the review applicant gets their opportunity to make their final comments.
Thank you, Chair. We say respectfully there can only be one determination in this matter, and that is of revocation. The facts are that this is not the first review hearing that we've been here. This is now the second within 7 months. What we've heard today appears to be a lot of passing of responsibility, a lot of words that have been exchanged as opposed to tangible evidence that have been provided. We have one email here that's offered late in the day that is questionable to an extent, but no other evidence that has been offered at all. The respective panel delivered a strong determination last time, and the premises licence holder clearly has not learned from the experience, even when represented. It's not beyond reasonable expectation for the licence holder to learn from this experience to ensure legal compliance and avoid reappearing before you today, i.e. providing that evidence, especially after being notified of a second review hearing. A suspension and amendment to the conditions has already been determined, yet no apparent impact has failed, and it's failed to address the root causes. The next obvious step is revocation. They don't challenge the circumstances in November, and obviously there was offences that was already been put out to you today. On the 23rd of January 2025, we say the premises were found not to be trading irresponsibly, they were found to be trading illegally. This was the case as documented in Appendix 2 in the comments from the licence holder that they were trading in November 2024. As mentioned already, it's not the licensing authority's role when determining guilt. That's for a court to do. Had the officer not visited, then we would argue that it's highly likely and reasonable to suggest that the licence and the premises holder would have continued trading other than in accordance with the authorisations. They certainly would not have been submitting a varied DPS application as suggested. Whether it was the licence holder or their respective agent, the company, whoever it was that failed to submit the varied DPS application, the facts are that one was not submitted, even when this was clearly explained at the previous hearing and in the respective determination. Recompliance, I'd already mentioned that to date hasn't been produced. It appears that some has been produced. There's some documentation that apparently been brought we haven't been given the opportunity to look at. Perhaps that's something that yourselves can have a little look at in due course. Now, Section 182 guidance, again, I know you'll be aware of this and be minded of it. It does mention that 11.10, a failure by the holder to respond to such warnings is expected to lead to a decision to apply for a review. That happened at the first review hearing. 11.18, where responsible authorities such as the police or environmental health officers have already issued warnings requiring improvement, either orally or in writing, that have failed to provide, failed as their part or their own stepped approach to address concerns. Licensing authorities should not merely repeat that approach and should take this into account when considering what further action is appropriate. That was the determination of the first review hearing. 11.20 is expected that licensing authorities should so far to seek to establish the cause or causes of the concerns that the representations identify. You can hear today, again, a lot of excuses being made from people in responsible positions that should know better. 11.22, it may emerge that poor management is a direct reflection of poor company practice or policy, and the mere removal of the designated premises supervisor may be an inadequate response to the problems presented. Indeed, where subsequent review hearings are generated, it should be rare merely to remove the succession of designated premises supervisors, as this would be a clear indication of deeper problems that impact upon the licensing objectives. Again, we've heard that the company were supposed to do something. Well, that's not acceptable. 11.23, so for instance, a licence could be suspended for a weekend as a means of deterring the holder from allowing the problems that gave rise to the view to happen again. It has happened again. But where premises are found to be trading irresponsibly, the licensing authorities should not hesitate, where appropriate to do so, to take tough action to tackle the problems at the premises, and where other measures are deemed insufficient, to revoke the licence. I could go on, but I know your time's precious. If a question came up in terms of whether this is a draconian approach, you know, mention about the theory of Wednesbury unreasonableness, for instance, the moral standard so outrageous in its defiance of logic, or accepted moral standard that no sensible person applied his mind to the question that could be decided could have arrived at it. In this matter, we would argue that all the evidence presented to yourselves from our side in both hearings would withstand such scrutiny, and that a sensible person would find no issue, show revocation should be determined. What we presented today offers a panel a sound and defensible rationale for why the premises licence again should be revoked. And as final comments, we say it is clear that licensing objectives are still being undermined, and Gloucestershire Constabulary respectfully recommends a subcommittee to determine revocation. Thank you.
Thank you very much. And finally, we hear from the premises licence holder. Over to you, sir.
Thank you very much, Chair. Chair, we're not going to be disputing that the premises was trading from 4th of November without the license transfer carried out. That matter was carried out immediately once the license DPS came to know about it, failure of the company, which we say to you. But furthermore, we are trying to make you understand that the breaches, the promotion of 4 licensing objectives were promoted by themselves without that license. When they were there, they were supposed to say to themselves that yes, that our license has been transferred, and now we have to promote, which we have proved to you that there is an incident book, there's a refusal book, there's a compliance, which she is supposed to carry out, the trainings and all that, and that were carried out. So that's all we could say at this very instance, and she is carrying it out. So that's what we can say at this moment.
Thank you very much. Right. We will adjourn to make our deliberations. So I propose let's adjourn for 20 minutes according to that clock. So we're looking at 4:45 for now, but Okay. So for members of the public watching on YouTube, the committee retired to take legal advice and to deliberate, and we now have a decision which I will start to read out. I'm just going to get some water so I can read it hopefully in one go. Okay. At the hearing, the subcommittee heard from the applicant for review, Gloucestershire Constabulary, and the representative for the premises licence holder. The review of the licence was requested by Gloucestershire Constabulary under the Crime and Disorder Licensing Objective. All relevant written and oral submissions have been considered. Legal matters. The subcommittee had due regard to the Human Rights Act, the provision of the Licensing Act 2003, which confers the power of the licensing authority to deal with the application, the obligation to promote the 4 licensing objectives, the relevant sections of the Council's Statement of Licensing Policy and statutory guidance. The Licensing Subcommittee considered that it must carry out its functions with a view to promoting the 4 licensing objectives as set out in Section 4(2) of the 2003 Act. The subcommittee considered all relevant verbal and written submissions from the applicant and the premises licence holder before making its decision on the application. They also had due regard to the Council Statement of Licensing Policy and statutory guidance. The subcommittee looked at the following issues. Human Rights Act. The premises licence holder have been given a fair hearing, every opportunity to provide documentary evidence to the police, the licensing authority, and allowed a late submission which has been given limited weight. PLC made an error, but there is no evidence of this. No refusal logs, no photocopies have been provided in advance, no training certificates, save for the one received today. The police have laid out their case in detail with evidence, and the premises licence holder has had multiple opportunities to present their documentary evidence. There are no public sector equality duties. The premises licence holder is represented, and we, as a committee, have considered whether there are any. The police have said that while the licensing authority are not here to look at guilt, in terms of the licensing objective of preventing crime and disorder, on balance of probability, they are failing. They are failing, and on balance of probability, the police have said they failed to produce the licence. There wasn't one in existence. On balance, they were selling without a licence, keeping alcohol for unauthorised sales, and ignorance of the law is not a defence. The law puts the duty on the premises licence holder and the designated premises supervisor, and the fact that this duty can't be delegated to others is down to them. The previous history of the matter, which includes selling alcohol persistently to children, not confident that they are promoting the licensing objectives. The request for documents was not dealt with sufficiently, and the administration of it was not up to scratch. We have heard words, but no documentary evidence has been presented. Whilst we note the comments about potentially being made homeless, this is not a material consideration. The licensing authority can only look at the licensing objectives. The police have presented very clear evidence. They have been warned by the police. They were reviewed and the conditions were changed. The designated premises supervisor was changed, and they have not sought to engage constructively with the police or the licensing authority. The police have applied progressively higher levels of trying to get compliance, and they have still failed to achieve compliance. The only thing the committee could do was to ask for the production of all logs, documents every month as a condition. And the question then is, we don't do this for anybody else, as it puts an unacceptable burden on the licensing team simply to watch one premises. So this, in our view, is not a rational decision to make. Since all other options have been exhausted, we have tried changing the DPS, we have modified conditions, and we have suspended the licence. Ultimately, if this is a genuine error, the premises licensing holder has the opportunity to appeal to the Magistrates' Court and can produce all documents to the court for their deliberation. We've not had evidence in document form of compliance with in compliance with our constitution, and we have had only limited weight to verbal assurances. There's no paper trail presented to the Licensing Subcommittee. The process hasn't been respected, and despite being given every opportunity, having been subject to a review 7 months ago. Therefore, the subcommittee have no choice but to revoke the licence, and this is its decision. Appeal rights. So all parties are reminded that there are rights of appeal against this licensing authority decision pursuant to section 181 of and schedule 5 to the Licensing Act 2003. An appeal must be made to the Magistrates' Court and commenced within 21 days of notification of the authority's decision. That's where the committee has decided, and that will be provided as a written decision notice within the statutory timescales. So that concludes this agenda item. The final item is any other matter that the chair determines is urgent and it requires a decision, and you'll be glad to know that there are none. And at 5 p.m, I determine the meeting to be closed. Thank you.